I'm really excited about this particular track. There's a large diversity of different types of institutional and technical, socio-organizational mechanisms, interventions that I think all deserve a place in the landscape of AI governance. My name is Roel Dobbe. I work across these kinds of interventions, leading the Socio-Technical AI Systems Lab at Delft University of Technology in the Netherlands. In this first half of the track, we will have, in order of presentation, Sunayana Rane from Princeton University, Florence from Stanford University, Jane Castleman from also Princeton University, Tran from the London School of Economics and Political Science, and then Eloise Gabadou from the AI and Democracy Foundation. So I'd like to ask Sunayana to get us started. Thank you very much. And thank you.
Hello, everyone. I'm Sunayana. I'm a JD PhD at Princeton and UChicago, respectively. Today, I'm going to talk about one of my papers at the intersection of law and AI on foreseeability of AI harms. Before I get started, I just wanted to ask who here is familiar with the concept of foreseeability as a legal term of art? Okay, a few people. Okay, so that helps me get situated. So the type of foreseeability that I'm talking about is legal foreseeability. The big picture idea is that the law only holds us accountable or responsible for the foreseeable consequences of our actions, right? So the idea is that, for example, if you agree to a contract and there's a big hurricane and that affects whether or not you can fulfill that contract, we don't want to hold you liable for the consequences of the hurricane. If you change lanes while you're driving and you accidentally nudge somebody's car into the path of a meteor, we don't want to hold you responsible for the meteor. This makes sense to everyone. We do, however, want everybody to consider the consequences of their actions. So in other words, the law uses this doctrinal concept of foreseeability in legal reasoning to hold us responsible for considering the consequences of our actions. So for example, if in that previous example, you're driving along and you swerve and somebody has to swerve to avoid you and they get into an accident, we do want to hold you legally responsible for that because it creates a right incentive structure for good behavior, right? Okay. The trouble with AI, as many of you may have already made the jump to, is that even those of us, the technical researchers building the AI systems, don't fully understand what is foreseeable about their behavior. They still have the power to take us by surprise. Their behavior is unpredictable. Sort of like what we were talking about in yesterday's panel on the AI safety report, right? There's an evidence gap in what we can understand about the future behavior of these systems. However, many instantiations of these technologies are designed to sound human-like. So they're designed to sort of hijack our machinery and make us think that their behavior is just as foreseeable as other human behavior that we expect to be foreseeable. So even though we know that AI behavior is unexpected, AI deployment, on the other hand, has not slowed down, and AI is already replacing human decision makers in areas where we expect those human decision makers to have stable, foreseeable, responsible behavior. So the result is what I call the foreseeability paradox, right? So the law is going to have trouble regulating unpredictable, unforeseeable AI behavior. And the way to make that behavior more foreseeable is to study it from all perspectives, is to characterize it, is to better understand it. However, those who could make that behavior more foreseeable and therefore make the AI landscape more safe are currently least incentivized to just do so out of the goodness of their hearts, right? Remember what I was talking about earlier. The law has set up incentives. That's why the concept of foreseeability came to be, right? The legal realist view is that the law can set up incentives to make this type of situation better. So there is a solution. Change the incentive structure to maximize the foreseeability of harmful AI behavior, right? So currently, frontier AI labs really don't have any incentive to, or are least incentivized to investigate, transparently disclose, and publicize the harmful natures of the AI that they're building, right? Because the less foreseeable it is, the less likely they are at a big picture level to be held responsible for it. However, those of us in the room who are involved with law, are involved with policy, have the ear of policymakers perhaps, here's a potential solution. Set up law and policy defaults or presumptions. For those of you unfamiliar with the world of law and policy, presumptions are just default rules that can then be overridden, provided more evidence. The policy presumption should be that humans should not be expected to foresee, or ordinary consumers, I should say, should not be expected to foresee the harmful nature of AI behavior because of the hijacking and the human-like tendencies that they are just designed to emulate. And the legal presumption, so the presumption that courts should make, is that AI creators are the ones that know the most about their AI systems. And so what this does, what these presumptions do, is that they force information sharing along all of these different axes. They incentivize information sharing along all of these different axes so that AI creators have to rebut the presumptions by sharing this information, and therefore can make the world and make the AI landscape safer for all of us. Thank you very much. If you have more questions or would like to chat, please get in touch.
Thank you, Sunayana. Next up is Florence. In the meantime, I encourage you to use the Slido environment to ask questions, and I will pay particular attention to those questions that address the broader themes emerging from this panel.
Thank you very much. Hello, everyone. My name is Florence. I'm currently based at Stanford. I'm a visiting professor at Stanford University. I'm originally from France, and I'm a law professor in France. And as a European legal scholar, I've been following extensively, of course, the drafting of the EU AI Act, which is an attempt to draft what I would call an ex-ante regulation. And we, of course, know those very comprehensive European regulations. It started with GDPR 10 years ago. We know how it's difficult to implement them, to enforce them, and this will probably be the case with the AI Act. So as a legal scholar, have decided to look at something else, something that is an ex-post approach that was just mentioned in the previous presentation, which is liability. And so what I would like to highlight is the fact that, yes, liability can incentivize AI providers, AI developers to be more cautious, to adopt a precautionous approach. And we know we have in legal scholarship various possibilities, various ways to incentivize AI providers to be cautious and to implement safety measures. We have negligence, we have strict liability. We have in Europe now a new product liability directive that covers AI, and depending on the type of harms and the type of risks that we focus on, we might use negligence or strict liability to incentivize safety. But of course, this needs to be articulated with insurance, because AI providers, of course, want to be covered for liability risks. They want to get insured. And what we could expect is that insurers in the future might play a role in imposing more safety. There is a line of scholarship about insurers as regulators, and we could probably expect insurers to, for example, through risk pricing, for example, to incentivize those AI providers to be cautious. Of course, this is contested currently in scholarship. You have scholars that say, we cannot rely on insurers to impose more safety. Why? Because insurers do not have the technical expertise they do not know enough about the technology to impose real safety measures. So they will look at the industry sectors. They will look at the number of clients that an AI provider has, but they will not be able to impose safety measures. There is another problem with this reliance on insurance, which is the fact that the biggest companies, they used to self-insure. So they have subsidiaries that provide insurance coverage that are called captives, pure captives. And so those subsidiaries are not conducted to impose AI safety measures to their group. So let's assume that Microsoft has an insurance subsidiary. We cannot expect this subsidiary to impose safety measures to Microsoft. So this is currently very much debated, but at the same time, we could expect insurance, for example, to require third-party audits to AI providers. So what is the final question here? The final question is insurability. So insurers will probably cover AI risks to a certain extent. They are starting to do so, but for certain types of risks, they will say it's not insurable. It's not insurable because we do not have the data, because it's too unforeseeable, because we are very much afraid of cluster risk. If you have one model that fails at some point, then all the others will fail. So this is now what is on the table and what is necessary, what we need to think of at the moment. Thank you very much.
Thank you, Florence. Next up is Jane.
Hi, everyone. My name is Jane Castleman, and I'm a master's student at Princeton University. I'll be presenting my work measuring validity in LLM-based resume screening, done with some great collaborators at the Center for Information Technology Policy at Princeton. So downstream users are pressured but excited to use AI, forcing them to confront the question of how can they measure model performance for their use case. For example, in the United States, there was a recent executive order stating that agencies should use performance-based techniques to best harness the rapidly developing AI marketplace. In response to the rapid deployment of AI, policymakers are increasingly demanding that decision-making systems be subject to performance evaluations. Again, an earlier executive order from the US encourages independent evaluations of vendors' claims concerning the effectiveness and risk mitigation of AI offerings, and this has been codified in state law in New York and California. More broadly, independent researchers have questioned the functionality of AI systems, noting that despite the current public fervor over the great potential of AI, many deployed algorithmic products do not work. Despite the urgency of evaluating these AI systems, general purpose benchmarks largely fall short. Existing benchmarks are generally unrelated to individual company and government use cases. There may not exist ground truth with which to measure performance against. And finally, this data may suffer from train test contamination, where once it's posted publicly online, the next generation of large language models is trained on this data. Given this measurement problem, we hope to confront it directly by developing a framework for scalable, diverse evaluations in decision-making scenarios. This work focuses on the case of resume screening, but we're optimistic that our framework can generalize to other decision-making domains like medical decision-making and safety filtering. So what does this actually look like? Well, first we have to design ground truth in decision scenarios. And so we start by specifying the necessary conditions that we think any rational decision maker must satisfy and principles for test case construction at scale. We do so using inspiration from software testing principles that provide a systematic method to evaluate behavior under very controlled conditions. So namely, we look at two different types of validity in decision-making. We first look at criterion validity, which posits that relevant criteria should impact outcomes. In resume screening, what this might look like is that a resume with an additional job relevant qualification should always be chosen over a resume without that qualification. Additionally, we can look at discriminant validity, which states that irrelevant criteria should not affect outcome. This is very similar to other work in fair decision-making, where if we have two resumes that have equal qualifications but differ in their irrelevant attributes, such as their race or gender, we expect a decision-maker to abstain from this decision rather than arbitrarily choosing one of these resumes. So now that we've defined these two notions of validity, we focus on developing these test cases of pairwise comparisons at scale. So how we do this is we pull job descriptions from popular job websites like LinkedIn and Greenhouse. We then generate a synthetic resume that satisfies all of these qualifications. To generate these pairs that test criteria on validity, we carefully add or remove 1, 2, or 3 of these relevant qualifications. And then to test discriminant validity, we just take this base resume, reword it, and then perturb the demographic information, again, as in previous fairness research. And so what we find is that validity in these models can't necessarily be assumed, even at the frontier. We find that even when just one attribute is changed between these resumes, models don't necessarily always choose the more qualified candidate. When looking at discriminant validity, we see an extremely large gap between the performance of smaller open models and their newer, larger counterparts, while encouraging that models are gaining the performance of abstention in decision-making of similar resumes. It's slightly concerning considering that some organizations have to rely on these smaller open models due to data privacy or cost concerns. Overall, we're excited about this framework because it allows us to simultaneously measure the validity and the fairness of decision-making systems. It can be scalable and customizable across a number of evaluation scenarios, which helps overcome some limitations of previous benchmarks. Additionally, because we construct these examples from live job descriptions on demand, we don't have to worry about trained test contamination, and we can actually accommodate longitudinal auditing, which is increasingly required in the regulatory context. And I would love to talk more about some of our other results in depth, so feel free to scan the QR code or find me at the poster session. Thank you.
Thank you, Jane. Next up is Hachi.
So good afternoon, everyone. My name is Hachi Chen. I'm from the London School of Economics and Political Science. And it's such a great pleasure to being here. And as you might notice from the opening remark yesterday until this morning's sessions, a lot of people actually mentions the role of middle power in the current AI governance. And in my speech, I'm going to continue this topic as well and focusing on certain middle powers that's called technological swing state to understand the ways these states might leverage AI opacity to enhance their power within the regions or globally. So technological swing state, by definition, is the middle powers that have both technical capacity and strategic flexibilities that to moderate the hegemon rivalries. The term swing state indicates that the middle power could swing between the two great powers, the US and China, and of course, maybe in some situations influenced by the decisions and actions made by two great powers. The goal of my research is to understand the behavior of these middle state within the context of rising AI opacity, to analyze the ways these technological swing states might transform AI opacity into the source of political power. There are three layers of opacity, I might say, in these situations. The first one is informational opacity, which emerges directly from the black box nature of AI and the political economic incentives that might privatizing performance over explainabilities and transparency. The second type of opacity is normative, which come from a diverse set of regulations, standard, or value. For instance, what exactly transparent, safe, and ethical AI is, and how should we implement these standards effectively? The last type of opacity is strategic opacity, in which state or government are unclear about the strategic path they should commit to in the future, and certain states might not know about their own political strategy to secure their access to technical resource, for instance. So these three different type of opacity might lead to shape the global AI dynamic very different way. For instance, I might say it increased the importance of institutional transparency mechanism, such as for auditing and validating. And in terms of state behavior, it might encourage states to find a way to preserve flexibility and avoid lock-in. Within this context, there are certain ways for middle power to jump in and leverage their type of opacity into strategic power. They can, for instance, become a hub for providing trustworthy validations or auditing mechanisms. They can also find a way to balance between different normative standards and translating, bridging, or even shaping the together like regulatory and governance regimes. And in order to clearly understand these strategic options, I analyzed 3 different case studies, which are South Korea, which represent delay and hacking mechanisms. Singapore is selective alignment, which act as a bridge between the local ASEAN and the global scale. And lastly, India, which perform as a normative shaper, bring together different forums from the Squawk G20 to the Global South and so on. The strategy and mechanism exercised by these states depend on their position within the technological network in the global scale and also in the nature of their technological capacity. Unfortunately, I cannot explain all of these things in just like a very short speech, so I'm very welcome you to come to my poster after this to talk more about this. But there's something I would like to for you to keep in mind. The first thing is that this mechanism is non-static, and it means that states in a certain way might change their behavior depend on the situation and also the objective. And second, I might argue that these state behavior derive from their strategic position within the network, but it doesn't mean that every other state having like very similar positions might exercise the same thing or achieve the same outcome. And lastly, for the most important thing I might say is, from my point of view, is to focus on the middle power actually can shift the narrative from the AI arms race at this moment to a more inclusive and of course responsible and maybe more ethical AI in the future. So, because this is an ongoing research, they of course have some limitations and directions I want to follow in the future. As you might notice, I'm not mentioning other middle state that might qualify for these situations. And I'm happy to have any critique or recommendations from any of you to make this better in the future. Thank you a lot.
Thank you, Hachi. And last one is Eloise.
I'm the surprise guest on this slide, apparently. So, hi everyone, I'm Eloise. I'm representing the AI and Democracy Foundation. So I'm going to copy Sunayana a little bit, and I want to ask the room, who has heard of deliberation here? Okay, who has heard of deliberation in the context of AI? Okay, quite equal. Okay, so, going next. So a clear one-sentence problem statement that I wanted to start with is that if AI advances continue, we are likely to see dramatic changes to the social contract and power structures that govern the modern world. So you've heard that from many of the presentations that we had here at the conference, but we want to focus here on mainly power concentrations in the hands of a few, gradual disempowerment of humans and their agency, and the change in the social contract. So the more automation happens, the more it's going to destabilize this foundation, the more it's going to demand a renegotiation of what entitles people to resources and participation in general, without any clear institutional framework to actually handle it. So our main contribution here is on this slide, which is arguing that democratic infrastructure, so that means the democratic processes or methods that enable collective decision-making, or the accountability and the governance structures that enable these processes are helpful for addressing blockers across key decision-making layers of the AI stack. And we're going to share a bit of I'm going to share a bit of results from our pilots across these layers, but basically these layers range from policy agreements. So that can be at different levels of governance, so national or international or local. But deliberation can actually help towards agreeing on complex policy stances around AI. The second layer is AI lab, or it's written AI org here, but in general, AI lab corporate governance. So using deliberation to avoid any mission drift or any forms of mission capture. So what we're currently working on right now is mapping the various internal and external pressures that can exist in an org that could lead to a mission drift. In an AI lab, so it can be like investor pressure, but also employee pressure, and seeing how democratic safeguards in general, or among other corporate mechanisms, could be set up at various stages of growth and influence of an AI lab. And this work is done in the context of an UK ARIA grant. And the third layer, so the AI system layer, is basically trying to use deliberation to align AI systems to a set of norms, values, and principles, and aiming to represent the complexity and pluralism in these. And what we're currently working on right now is using deliberative processes in general to specify the risk thresholds of a specific model, for example, and defining the technical specifications of a model. This work is also done as part of the ARIA grant. So just a little 101, but democratic processes exist in many forms, voting, referenda, surveys, public consultations, but what we're focusing here more is what we call representative deliberative democracy, which are basically includes process like you've heard probably of citizens' assemblies that can happen at different levels of governance again. And these have a very whole slew of very useful properties, including random selection, that can dramatically, for example, mitigate power concentration. And the basic ideas here is to get a representative subset of the population, so what we call a population microcosm, and give it the time and the resources to really dig into an issue and make a determination on it. And even the current imperfect versions that we have now are being used across the world in different governments and increasingly by companies. So the OECD has a database of those if you want to check it out. It's more than 700, 800 now cases of deliberative processes being used to deliberate on complex policy stances. And going back to the different layers that I showed with that knowledge, deliberation here helps create the right information in representative space for that deliberation and create the right checks and balances in corporate governance. So for example, looking at unforeseeable harms, we want to make sure that AI labs also have the space to intentionally address those and discuss as part of their corporate governance strategy. Having said that, all those beautiful things about deliberation, we're very honest about mapping and being upfront on the various gaps that currently exist in deliberative theory and practice, which is why we're working on something we call the gap map that we'll be releasing a second version soon, so be aware of that. And we're mapping where some of the properties are falling short. Thank you. I can talk more about it later, but thank you so much.
Thank you, Eloise. As I promised, a very rich fabric of different kinds of interventions, frameworks, approaches to AI governance, from technical to social, organizational to institutional. You nicely already brought them together in the last presentation. So what I'd like to do to set up a different kind of dynamic, hopefully in the panel, than just me asking questions, is for you to reflect on how do we actually, because it takes a village to raise an AI industry or to raise an AI field of scholarship, of advocacy, of policy. How do you look at each other's interventions and work, and how could it actually productively be in interaction with each other, or synergize, or otherwise leads to productive future research questions or efforts that, we might have not otherwise identified today? Start with you, Sunayana. Okay.
I can try to. The question is essentially like draw all of us together, which is a challenge. It's a challenge.
You can start with one linkage.
Okay. I can try to do a little bit more than that. As you all were speaking, I started to think about how we're really talking about empowering different disciplines to have more informed, structured, analytically sound conversations. And so, we're talking about information forcing to make unforeseeable harms more foreseeable. We're talking about mandatory insurance to try to make sure that the incentives are aligned for people to actually look into those things. But then we're also talking about, that's from a practical perspective. We're talking about from a bigger picture, theoretical perspective, like how do we actually implement the correct structures once we have a little bit more information is some of what I saw from the other panelists as well, right? So big pictures, we need a lot more information. Can our existing institutions like insurance regimes or law and policy help get that information into the light and then have the various different disciplines engage with it in a way that actually improves the overall conversation? At least that's what I heard. Does anyone want to add?
I can add a little bit. I think the main connection I see is, I know that in my democratic space, some people are trying to experiment more and more with talking to future generations. And when I say that, it's even integrating non-human species in the conversation. How do we kind of simulate a world where we can talk to the future generations that aren't even born now? So there's a big move towards trying to foresee some harms without, I'm not saying predicting, but just trying to expand the different policy choices or not even policy, but just choices that we have in general to make better decisions now. And I think that's what you were saying. It's not a question of predicting, but an actual creating the space to actually gather the most information to treat that foreseeability and trying to make AI labs more accountable to mapping those foreseeable harms, because they're the ones who are the closest to the knowledge to actually discuss that.
Happen.
Yeah.
Achie, maybe do you have any reflection on how middle power swing states can actually broker some of this sort of information problem and integration problem?
Well, I might think from my perspective, when I hear a lot of interesting opinion here, what's in my mind is that there's a lot of linkage between our speech, which is when I hear about you talking about unforeseeable harm, and then you talking about insurance, I'm just thinking about transparency or transboundary AI harm, which is a lot of AI foundation model actually concentrates in the US, in the EU, or in China, but actually it deployed all over the world. What if there is some harm that happened from one country to another? Do we actually have something very similar to nuclear conventions that we have previously? That's my and what is the role of middle state power that can contribute to realize and also build that kind of international liability regime to happen like that. So I think there's a lot of link that between the speed that we are talking right now, and then there's a very bigger picture that we can focus in the future and see what kind of world that we want the the future technological order to be improved to. Yeah.
Thank you. I'm going to go to the other two speakers with the time left. So from the audience, there's a sort of set of questions around insurability and foreseeability. So can AI arms be insured or foreseen in a way that naturally incentivizes safer system design? What are solutions or inspirations? What can we learn from nuclear industry, financial market risk? Maybe for you, Florence?
Yes, so it's a complicated question because you have, on the one hand, the possibility to rely on insurance markets, which assumes that those AI risks can be insured, which is not established, and insurers are very, very cautious about this. And so then, if some of those AI risks cannot be insured because we lack the data, because for various reasons, then of course we need to find other solutions like public backstops, like compensation funds. This is what currently is considered here in France, looking at what happened for what we call national catastrophes. And so this is, for now, and this is what I would plead for, very much understudied. And so this is the reason why we need more studies and scholarship about these frameworks.
Like Jane's.
That's an excellent call. So maybe, Jane, do you have a final reflection before we close the panel?
Yeah, I think my work was a little bit distinct from some of the others, but what I kind of took is that we needed more information surfacing and transparency from these companies, which is great. And I think regulations that enforce this are well-intentioned, but without the tools for downstream deployers and these companies to actually collect this evidence and demonstrate these harms, it's really difficult for companies to actually make interventions productively.
You're helping to create those tools, Jane.
Hopefully.
Yours was the work that demonstrated what we were trying to say, was the information surfacing.
What an excellent integrative conversation. Thanks, everyone. Please join me in thanking the panel. Thanks. And with that, we move to the second part of this track. Just give me 1 second. And I'm welcoming on stage, please have a seat here on stage, Karl Koch and Abra Gans, which are from the AI Whistleblower Initiative and the Center for AI Risk Management and Alignment. Mackenzie Jurgensen from Northumbria University, Susie Lindsay from the Law Commission of Ontario, and Zoltan Turbeek from GCSP. And we're getting started with Karl and Abra for the first presentation. And please give them a warm applause.
All right. Hello, everybody. Great pleasure to be here. As introduced briefly, Abra Gans, Karl Koch from KAMA and the AI Whistleblower Initiative. We have a lot to get through. Let's get into it. We want to talk to you about whistleblowing in AI. AI is a unique situation, especially on the governance side, where core challenges include intense competition between companies, potentially leading to safety skipping and completely novel risk. We've heard it, I think, in previous sessions as well before, which means risk can be dramatic, but it can be very difficult to spot them outside in, for example, from a regulator or like an eval perspective. These issues kind of exist in other industries, for example, in the finance sphere. That's also very quickly moving and can be intransparent and obfuscated potentially as well, which makes it difficult to assess. There, a solution is whistleblowing. For example, in the US, on financial fraud uncovering, we see around 90% of fraud is being uncovered by accounting, auditing, and significantly more than double by whistleblowing. Protections can go further. They can also, for example, include protections for insiders raising public health concerns. Which means whistleblowing works as both an intervention mechanism stopping misconduct as well as a deterrent mechanism preventing misconduct. Today in AI, however, we see companies, maybe sometimes out of good motives, aim to prevent insiders from raising concerns, also to, for example, the outside. OpenAI try to prevent insiders from disclosing also to regulators about risks through the non-disparagement agreements. We see fragmented protections and a lack of awareness in insiders, which means today we think that those insiders who are best positioned to spot risks will not have the ability to raise concerns, and we won't hear the alarm bells. So for today, we want to briefly run over understanding what is the current landscape of protections and how we can improve it. With that, over to Abra.
So I'm going to talk to you a little about what the current legal situation is like across jurisdictions. Of course, this varies a lot. So what do you need for a whistleblowing law to work? Firstly, you need for anyone who spots issues to be able to raise them safely. Secondly, you need regulators to have the capacity and the capability to respond to those risks when they're raised. A whistleblower can report safely, that is, they have legal protection, if they meet sort of 3 conditions. And these 3 conditions or factors depend on what you're reporting, who you are, and to whom you're making that report. So, going into a little more detail, what you can report. In some jurisdictions, you never get protections. No matter what you're trying to report, even if it's a violation of the law, nothing. Then in many jurisdictions, any violation of the law, no matter what law it is, so for example, if you have an AI-specific law as well, you can go to a regulator and report that. You can go internally as well. And then there are some which also include this risk to public health and safety. So in many cases, we're not able to enumerate all the risks that there are. Maybe technology is moving so quickly that actually law is not able to keep up with every single risk. So it makes sense to have that sort of general clause as well as specific laws that you're interested in. So, who can report? Well, wherever you have a whistleblowing regulation, you can this varies a little. So it can go from no one to everyone in some jurisdictions. Most jurisdictions fall in the middle, where you can have all employees able to report. And some extend that a bit as well, including contractors, for example. And then to whom you can report. wherever you have a whistleblowing law, you can always go internally. So most people don't think this, but talking to your boss, having a chat, saying you've seen an issue, that counts under whistleblowing law. You should be protected for talking to your supervisor if you see an issue. Then in most places, you can also talk to regulators if there's something serious. And in some cases, if there's an imminent and material harm, you can go to the public as well, where it's really urgent. So that's the whistleblower side. And then for the capabilities of regulators, well, for this to actually work, you need to have a regulator. Not all jurisdictions have a regulator for AI. It's pretty new, but some do, and some places, they have very good enforcement powers as well. Here's a little summary. Come speak to us, look at our poster outside for more details. And now we're going to go on to how you can actually improve the future and improve these sorts of issues.
Exactly. So if you find yourself speaking with an insider, let's say working at a frontier AI company, the first thing you should tell them is, as early as possible, find legal counsel. Most people only go finding legal counsel once things are already pretty bad. Insiders can go get legal counsel very early. There's no commitment. There's great pro bono options available. We help insiders connect them to pro bono options or defense funds. That's the most important. You don't need to investigate yourself. Insiders can rely on reasonable cause to believe, so they don't need to prove a violation of the law, just have reasonable cause to believe there was one to be protected. And be careful, don't download stuff from your work machine. People are taking a look.
So now, briefly to talk about the policy options. Firstly, strengthen the position of whistleblowers. In the US, at the federal level, there's the AI Whistleblower Protection Act that has not entered law. This has been proposed, it hasn't come in. That will be great. Also, whenever you write an AI law, make sure that you can spot violations, reduce the burden on insiders by actually improving transparency laws generally, and then finally, strengthen regulators' capacity to respond to those violations. Please speak to us more outside. Thank you.
Thank you both. And up next is Mackenzie.
Alrighty, hi everybody, I'm Mackenzie, and I'm very excited to speak to you today about a collaboration that I did with folks at University of Amsterdam, TU Munich, and with Algorithm Audit, a Dutch NGO. So to get going, the Dutch Executive Agency for Education, or DUO, used an algorithm across 11 years to detect fraud in student loan cases. And this covered 350,000 students. This was the process that DUO used, and I'll put your attention on step 1, which is around the risk profile. And this is where they used an actual algorithm, a rules-based algorithm that took in type of education, age, and the distance to parents. And then, depending on the risk score that came out of that, then a desk research or human analyst would decide, okay, do we need to conduct a in-person house visit? And then so on and so forth, the fraud outcome would come, and then students could appeal if they wanted to. And what we found is that the students that were appealing, the majority of them were students that were from non-European migrant backgrounds. And this seemed like something was going wrong then in that DUO process, which I just showed you. And so in 2023, the Dutch education minister ended up saying, hey, let's pause this algorithm, let's pause this process. And then they called for investigations. And Algorithm Audit was one of the organizations that was called to the table to conduct an initial bias audit. And lo and behold, by 2024, the Dutch government did come forward and apologize because of this indirect discrimination that was at play, and they compensated the students as well. So we, though, as researchers, were wondering, okay, this was a pretty unique case because we had the internal data that then went into the algorithm, we had the risk scores that came out of the algorithm, we also had the ground truth data from the Statistics Netherlands, which is the Dutch Office of National Statistics. So we could actually compare, okay, is this person a migrant or not? And so we were wondering, well, in the real world, oftentimes when you want to do bias audits, you don't have demographic data. You don't have that ground truth data, and that's a big challenge. So we were thinking, okay, what if we could use unsupervised learning to actually uncover the same or similar bias that we did in that initial audit. So that's what we did in this paper. and we focused on that step 1 of the process. So to give you a little insight into our methodology, for those of you that are aware of the algorithmic fairness community, you might have heard of the fairness metric demographic parity. So that's the equivalent of the bias metric that we used here, where we were trying to understand is the risk of a non-European migrant student equivalent to or has the same probability as a Dutch or European migrant student being classified as high risk by the algorithm. And then our data sets included the duo data. So as I was saying, those 3 variables that were plugged into the algorithm, as well as what the algorithm outputted for the risk scores. And then we still had that ground truth data of migrant background from Statistics Netherlands. But I will say that we did not plug that ground truth data, of course, into our clustering algorithm. That Statistics Netherlands data was only used for later on evaluations of how effective the unsupervised tool was. And this is just a little figure here to show you what actually goes into the, what we called was the unsupervised bias detection tool. But at the heart of that is a hierarchical bias-aware clustering algorithm. And this has actually been built upon from prior work, but I would say check out our paper for some of the improvements that we made for this work. And overall, though, our contributions were, 1, that we conducted a large-scale audit in a very real-world case study, and that we were able to provide an open-source unsupervised bias detection tool. And I just want to highlight to check out the web app, which is for folks who may be on the less technical side, but have a data set that they want to plug in and see if there are potentially some bias going on, some unfair decisions happening. And then also a link to our paper. But algorithm audit, Urian was not able to make it today, but if you're curious to learn more about the tool or maybe contribute to even improving the tool more, please do reach out to him. But for now, please come speak to me or Kirtan, my fellow co-author, to learn more about the paper. Thank you so much.
Thank you, Mackenzie. Next up is Susie.
Hi, my name is Susie Lindsay, and I'm a lawyer with the Law Commission of Ontario in Canada. Today I'm going to talk about a human rights AI impact assessment that we created. First, I'll talk about the problem we wanted to solve, then the solution we came up with, which is the impact assessment, and the challenges we faced. So thank you to my colleagues here. The issue of discrimination is well known. It's a known harm that AI can discriminate. Mackenzie's great example she just gave. These systems can discriminate unintentionally on race, age, sex, disability, a number of harmful ways. In Canada, our human rights framework doesn't allow this type of discrimination, with very rare exception. The gaps that we found that are exaggerated in the context of AI is that it's a complaint-based system, which means someone has to bring an action to court or take it to the Human Rights Tribunal. It can take years, it can take a lot of resources, and even if the decision goes their way, it can be an ineffective and inefficient way for a one-off decision to be the way to mitigate human rights harms in AI. So to proactively, to proactively encourage human rights considerations in the deployment of AI, the solution we came up with is that every AI governance toolbox for public entities, for private entities, should have a human rights AI impact assessment. This isn't a sort of nice to have, it's the right thing to do from an ethical standpoint. It's really a legal compliance tool. We designed it based on the Supreme Court of Canada decisions, the Human Rights Tribunal decisions, and the relevant statutes. We took that basket of laws and we operationalized them for designers and deployers of AI to consider when they're creating and deploying AI. And I'm so happy that people today are presenting ways to make it better. The assessment tool is a series of structured questions, And depending on the answers you give, you're led to mitigation steps. And I can see all the work that's going to make the mitigation steps that much better. But we're trying to link your human rights obligations with concepts like disclosure and transparency and auditing. We created this tool with the Ontario Human Rights Commission and Canadian Human Rights Commission, and we consulted widely across Canada. As any time with consultations, the same sort of 12 issues kept coming up. I put 4 here on the screen, but we did a background paper where we go through all the issues we faced and discuss how we dealt with them. It's also on our website, the Law Commission of Ontario. But one of the most popular questions we got was, is this mandatory? Are we going to have to do this impact assessment? And across the board, policymakers in government, industry, stakeholders, technologists, all said unanimously, we're not going to do it unless it's mandatory. And that was really interesting for us to hear because it made us realize how important this is from an educational standpoint. Because under our existing law right now, without any amendments, there is a positive obligation to take reasonable steps to ensure you're not discriminating. So this is us serving up, here are the positive steps you need to take to ensure you're not discriminating. Because even unintentional discrimination is a violation of our human rights framework. After we released it, the federal government of Canada adopted the human rights provisions and imported it into the federal government of Canada's algorithmic impact assessment that applies to all federal departments. So in some contexts, it's mandatory. The other question we got is people wanted to know if they'll get a passing grade, a score, better yet, a check mark saying we're done, we're in the clear. That was a lot of interest from industry and technologists. Human rights experts recoil at the idea of that. There's no clear quantification for discrimination under Canadian law. There's no amount that's okay. And no one wanted to give an in the clear for potential future human rights violations, which is why we ended up linking the risk assessment with the amount of mitigation you need to do. And where we go from here, as with any AI governance tool, we are revising constantly and talking to people, and I would love any feedback that anybody has. The biggest message we've gotten is it needs to be simplified in order to be more accessible to people. And the next step we're doing is we're working with the privacy commissioners in Ontario and Canada to add privacy in. Thank you.
Thank you, Susie. Last up is Zoltan. And let me remind the audience that there are no questions in the Slido environment yet. And again, I encourage you to raise questions that go across different talks and insights from the different speakers. Thank you.
Okay, good afternoon, everyone. It's always nice to speak as the last one, just before the end of the whole event. So my name is Zoltan Turberg. I'm a former diplomat. I took part in negotiation of the Council of AI Treaty, Council of Europe AI Treaty, and also the UNESCO document. And now I'm a fellow at the GCSP, the Geneva Center for Security Policy. I will talk about the socio-technical governance of AI through international standards today. I think as we all heard today and also yesterday, AI governance is expanding fast, right? We have hard law, we have soft law, we have national strategies, we have political declarations. So the issue is no longer a lack of rules. The issue is alignment and coherence. And without these, we risk fragmentation. So the key question is that who turns governance principles into technical reality? And I claim that standards, technical standards do. International standards are developed mainly, but not only, by 3 organizations. The IEC, which is the International Electrotechnical Commission, ISO, International Organization for Standardization, and ITU, the International Telecommunication Union. All of these organizations are based in Geneva, and they operate globally. And IEC brings together more than 30,000 experts from over 150 countries to develop standards for the electrical, and connected world. ISO represents 175 national members, covering 98% of global GDP and 97% of world's population. And we have ITU, here the UN Specialized Agency for ICTs, which ensures global interoperability of telecommunication networks, which is key for AI also. So these are global institutions for technical standards development, and they operate on the basis of consensus. But consensus is interpreted in a bit different way. It's not unanimity. IEC and ISO define the concept of consensus as general agreement characterized by the absence of sustained opposition to substantial issues, which means that no country can block alone the development of standards. AI governance works across 5 levels. We have hard law, such as the EU AI Act, or we have the Council of Europe AI Treaty that I mentioned. We have soft law, the UNESCO recommendation, or the OECD AI principles. We have national laws and strategies. We have voluntary international standards, and we have, as last, the technology and practice. And standards sit in the middle. They connect policy to implementation, and they translate principles into definitions, documentation, testing, and risk management requirements. And standards are voluntary, but despite of that, they shape how systems are built. And they can also be turned into binding obligations through regulatory and contractual mechanisms. And it is important that AI is not only technical, it is socio-technical, and AI systems affect access, safety, privacy, and our human rights. And this has been widely recognized. In recent years, OHCHR issued reports on human rights in technical standard setting. The Global Digital Compact adopted in 2024 called for closer cooperation among standards bodies and interoperable AI standards that respect human rights. And in December last year, IEC, ISO, and ITU organized the International AI Standards Summit in Seoul, Korea. And the Seoul statement adopted at the summit identified 4 priorities. You can see those on the screen. So incorporate socio-technical dimensions into standard development, understand the interplay between international standards and human rights, strengthen inclusive multi-stakeholder participation, and enhancing public-private collaboration and AI capacity building. So why is the Seoul statement relevant? Because first of all, it gives the green light for stronger cooperation among these bodies. And secondly, it provides the authority to incorporate the socio-technical dimensions and human rights aspects into these processes. But the work has started, and IEC expanded training and awareness raising activities through webinars, for example. ISO launched capacity building programs. ITU had an informal survey which showed that 84% of the respondents see human rights as relevant for standardization. And they may also develop checklists for this. All 3 organizations also engage with the Council of Europe on the hood area impact assessment methodology. But gaps remain, just very quickly. So translating human rights into technical language is complex, coordination takes effort, and participation gaps persist, especially for civil society and developing countries. Standards alone will not solve governance issues, but without standards, governance will not be implemented. So the priority should now be on coherence and bridge building between law and design, regulators and engineers, national and international processes. There is still much to do to improve, but this is exactly why this is the moment to engage. Thank you. Thank you.
Thank you, Zoltan. We have 6 minutes. It's a very short panel, so let's jump into it. I want to first return to the first speakers. You already actually provided a lot of actionable advice for what can be done to improve the conditions for whistleblowers. So I was actually wondering if you have any reflections on how the work of whistleblower protection sort of interacts with all the work you're seeing here with other kinds of like governance interventions, whether they be technical frameworks or human rights assessments or the standards. Do you see areas where actually, there is synergy or ways that work can actually directly or indirectly improve your the cause that you're working towards? And here's
Thank you. So, I think probably overall it's good to see whistleblowing as like one transparency and enforcement mechanism. So actually making sure that the laws that do exist do in fact get enforced. I think, Abra, you're probably going to talk a bit more about like third-party auditing side in a sec. Having standards is sort of the baseline for reporting them, both directly making it easier for individuals to spot what is actually a violation of that standard. And then also having enforcement powers kind of aligned with it, and like whistleblowing in that sense is like an enforcement mechanism.
So then just briefly to add on to that, there are some places where people are not currently legally allowed to sort of blow the whistle. In many jurisdictions are not allowed to report on things. So suppose you do have an auditing mechanism, you do have third-party people coming in, then often, even if they tell the company that is performing some misdemeanor and that company does not fix anything, they're not protected if they go anywhere else to report that. So evals orgs, for example, are not currently protected. So if a company does not respond to them, they have no recourse. So that's maybe another way which it interacts with other parts of this ecosystem.
Thank you very much. And I think the first message you said, like this is one of the mechanisms, and I believe that is something we should keep normalizing and also destigmatizing, however hard it might be in certain jurisdictions to actually enact them. So the question for the others, they're working on audits, forms of audit standards and governance. A recurring challenge is often that when we've done these kinds of assessments, if we can do them properly, the next question that those that are responsible for designing or governing a system ask, at least in my experience, is okay, and now what? How do we sort of make these insights actionable? What are technical interventions? What are organizational or regulatory interventions internally or externally? What are your core insights and challenges, or maybe even questions for this audience to also to push this work more towards implementation and validation and making these interventions effective in the real world?
Testing. Okay, great. Yeah, it's a great question. And I think the work that we did initially, I want to stress that that was a quantitative assessment, and that the next step would then be a qualitative analysis to think about, okay, are the clusters that we got, what are the different characteristics that were within those? Does this actually surmount to indirect, direct discrimination, depending on the case? And the beauty of like this kind of ethics community is that there are so many fairness metrics out there. There are so many fairness or bias mitigation methods out there. Sometimes it can be a little overwhelming to be a researcher in that space. And I think part of the reason there are so many is because fairness is so context specific. And so what might be fair in one context very well might not be the case in another. So you really need to be thinking about, okay, what is actually unfair within this instance? And then making your decisions with respect to your metrics that you're testing for evaluation, how you're conducting your audit, and what kinds of, if you find bias, then what kinds of mitigations do you want to do for that? So that's probably my technical take, but maybe the governance side or standards? Yeah.
Well, I would just like to point out that this is such an interesting mix of people, because what our job has been is to tell people you have to take these mitigation steps. And I like seeing how these steps just keep getting better. Like Mackenzie has shown how audits can be better. And one of the complaints we hear is we can't test for human rights because we don't have the information because of privacy, which can be true in some cases. And in some other cases, human rights experts might say it's an excuse. So it's great to see that's getting better. And we have whistleblowing as one of our mitigation steps. You should have an internal process for whistleblowing. And here, you guys are making that easier and better. And I think that all of these steps help us get to lower the risk of AI in general and really help people to adopt it more readily.
And if I may add my personal experience in the Council of Europe Committee on AI, when we were, I fully agree that translating policy instruments into practical tools is extremely difficult. But I think the key is that you involve all the relevant actors. So you have the policymakers, but with respect to the hood area methodology that we negotiated, we also had the standard setting organizations there, IASEAI, ISO, now ITU will also join. Those who will be affected should also have a say on the document. So actually, we reached out to the private sector, so those who will be really affected, and then they could also voice that, okay, it should be more user-friendly, it should be simplified. So I think it's very similar to what the Canadian experience also shows. Because technical people will not, I mean, they will need to have really practical tools. So I think, yeah, those are the key, that, like multi-stakeholder dialogue, and then simplification as much as possible, and then user-friendliness. Thank you.
Excellent. Yeah. Unfortunately, there's a next session coming up. So I'm concluding here. I'm encouraging the speakers to go onto Slido and to actually provide a look at the questions, maybe provide some answers there. And I want to thank everyone for joining. And next up is in the main hall, room 1. There's the closing session for today with Geoffrey Hinton. Please join me in thanking the speakers one more time.